Good evening, ladies and gentlemen. My name's John Bond. I'm a judge of the Court of Appeal in the Supreme Court of Queensland. On behalf of the Chief Justice and the judges of the Supreme Court, can I welcome you all to the Banco Court on the occasion of the W.A. Lee Equity Lecture for 2024. I extend a particular welcome to our speaker tonight, the Honourable Julie Ward, President of the New South Wales Court of Appeal, and I welcome back to what I hope is a happy hunting ground for the Honourable Margaret McMurdo AC, former President of the Queensland Court of Appeal, present tonight in her capacity as Chair of Queensland Gives. The major sponsor for tonight's event is the TC Beirne School of Law at the University of Queensland. Representing the School of Law is Professor Rick Bigwood. He's the Academic Dean and the Sir Gerard Brennan Chair of Law and Head of the school, as I've mentioned. His principal teaching and research interests lie in equity and contracts and property law, and he's been widely published in those fields. I call on him to deliver the official welcome and to formally introduce our speaker. Professor Bigwood.
Thank you, Justice Bond, for your kind introduction. All the introductions I've had, yours is the most recent, so thank you for that. And may I also extend my own welcome to your honours and other distinguished guests and audience members to this, the 25th Annual W.A. Lee Equity Lecture 2024, hosted by Queensland Gives and the UQ Law School. I acknowledge and thank the Honourable Margaret McMurdo AC as Chair of the Queensland Community Foundation for the opportunity to partner with the Foundation to present this event. Let me also begin by acknowledging on behalf of the University of Queensland and Queensland Gives the traditional owners and their custodianship of the land upon which we meet here this evening. These are the people of the Yurruga and Turrbal nations of Meanjin, which we now call Brisbane. I pay my respects to their elders past and present and extend the same respect to other Aboriginal Torres Strait Islander peoples present here this evening, or perhaps watching the recording from a different location later. I acknowledge the contemporary Queensland First Nations community who continue to maintain their identity, culture and Indigenous rights. We recognise their valuable contributions to Australian and global society. Now, the W.A. Lee Equity Lecture is held each year in honour of foremost Equity and Trust academic and author Honorary Professor W.A. Tony Lee. This prestigious series of lectures continues a long tradition of maintaining contemporary debate on matters of equitable jurisdiction, technique, principle and doctrine, both in Australia and beyond. Tonight's lecture is titled A Tour of Contemporary Developments in Equity, and I'm delighted that it will be presented by the Honourable Justice Julie Ward, President of the New South Wales Court of Appeal. It's my next job to read out a bio. I was very depressed and felt like a personal failure after comparing myself to her, but take that as a sort of a trigger warning. It's a very impressive bio, if I may say so. Justice Ward studied arts law at the University of Queensland, graduating in law in 1982 with first-class honours and the University Medal. Her honour was admitted as a solicitor of the Supreme Court in 1982. Following graduation, Justice Ward worked as an associate to Sir Nigel Bowen, the first Chief Justice of the Federal Court. Her honour then worked for Stephen Stone James, now King and Wood Mallesons, for 2 years before completing the BCL with first-class honours at Oxford University, having won a postgraduate scholarship from Sydney University. Justice Ward made a partner of Mallesons in 1988, the youngest female partner to be appointed to that firm at that time. Her honour was appointed to the Supreme Court of New South Wales 10 years later in September 2008. She was the first female solicitor directly appointed to the Supreme Court bench. She sat in the Equity Division of the Court until her appointment to the Court of Appeal in November 2012. She was appointed Chief Judge in Equity in March 2017 and then appointed President of the Court of Appeal on 6th of March 2022. I now invite Justice Ward to the lectern to deliver her lecture.
Thank you very much, Professor Bigwood. Thank you for the introduction earlier, Justice Bond. I too pay my respects to the traditional custodians of the land on which we meet, their elders past and present, and I recognise their enduring and long-standing connection with the lands in this area. I'm honoured indeed to have been invited to deliver the 25th WA Lee Lecture. Apart from the fact that equity, whether conceived of as an area of study, practice or perhaps a mode of conscience, is very dear to my heart as a former Chief Judge in equity, it's a privilege to be able to pay tribute to a formidable equity scholar whose texts grace the bookshelves of judges, academics, practitioners and students alike. The now retired, but still academically astute, Professor Tony Lee was born in Wales in 1930 and educated in law at Manchester University. He practiced widely across England and Wales before arriving at the University of Queensland in 1965 as a senior lecturer. He retired from that position in 1989 but continued in the law in various roles after that. Now, although I was studying law back in the dark ages while Professor Lee was still in full force as a lecturer in Queensland, since I was south of the Tweed, I didn't have the good fortune to be able to count myself as one of his students. But I was fortunate enough to speak with Tony briefly when preparing this paper, and I can attest to his continuing interest in trusts and his concern that equity not ever be reduced to some statutory formula. Of Professor Lee's works, I need say little other than to note that his pièce de résistance, Principles of the Law of Trusts, is surely never long enough on the shelves to gather dust. The last time I spoke in this courtroom was when I spoke on the topic of fragmenting equities. And I was speaking then about taxonomical issues in relation to proprietary and promissory estoppel and the like. Tonight I thought I'd take a different step. Having reviewed some of the topics that lecturers who's given this lecture before have given, I thought what I would do is to take you around the grounds, so to speak, on a virtual tour of some of the contemporary developments and issues in equity, which speak, I think, to the dynamic nature of equity. Now, I make the disclaimer in advance that I have drawn heavily on some recent decisions of my own court, the New South Wales Court of Appeal, but I can also make the caveat that we're awaiting the High Court's consideration of at least two of those decisions, so who knows, whichever way the High Court decides, the grant of special leave at least validates my belief that they raise some novel issues worth discussion tonight. The first decision, in respect to which special leave was granted earlier this year and which has been heard by the High Court, is one where, perhaps most interestingly, there was a divergence in view between the majority, comprised of Justice Leeming, a well-known equity scholar and academic as we know, with whom Justice Kirk agreed, and our Chief Justice, who was in dissent. So let me tell you a little bit about that decision. It was Jakin Properties Australia, Pty Limited and Neyman. And what was at issue for consideration was whether fiduciary duties are owed by a successor trustee to the predecessor trustee. It will come as no surprise. I've already told you that there's a divergence of views on our court about this issue, so we're eagerly awaiting the High Court's decision. It may come as more surprise that it has also been the focus of academic commentary in England as well, if you read some of what Charles Mitchell has been writing. So you might be familiar with the facts, but let me just reprise them briefly. The case concerned a family trust. The first appellant, Jakin, had replaced the former trustee, JPG. The respondent, Mr Neyman, was a judgment creditor of JPG for over $3.4 million. There was no dispute between the parties that Mr Neyman could be subrogated to the rights of JPG to be indemnified out of trust assets for liabilities incurred by it, including the judgment debt. But Mr Neyman's complaint was that Jakin had improperly transferred trust assets to other parties such that there were now insufficient assets to satisfy the judgment debt. Mr Neyman contended that Jakin, as the successor trustee, owed a fiduciary duty to JPG as the former trustee, broadly speaking, characterised as a duty not to deal with trust assets so as to jeopardise the former trustee's entitlement to an indemnity out of the assets. So, there was no question that a successor trustee owed obligations of some kind to the former trustee, the question was whether those obligations were of a fiduciary nature. Significance being as to whether or not, when those assets were transferred to a third party, it was necessary that the third party have knowledge of the trustee's fraudulent design. On a finding that the obligation was fiduciary in character, those third parties who received trust assets or who assisted in their transfer would be personally liable, pursuant to the principles set out in Barnes and Addy, with which you'll be familiar. The primary judge was Justice Kuntz. Justice Kuntz found that the obligation was fiduciary in character. His Honour summarised his conclusion on this issue as in the following, quote, JPG, and by subrogation Mr Neyman, was entitled to follow those assets into the hands of third parties other than bona fide purchasers for value without notice, who will hold them on a constructive trust imposed by the court in aid of JPG's proprietary interest in the trust assets. The appellants submitted that the course adopted by the primary judge constituted a radical development of the law that was unsupported by authority, devoid of reasoning and wrong in principle. So how did they fare in the Court of Appeal? Justice Leeming wrote the main judgment, and Justice Kirk agreed with him but added some other comments. Justice Leeming pointed out that while disputes between former and successor trustees are far from unusual, a fiduciary obligation of the sort propounded by Mr Neyman had not been established. His Honour commenced by noting that the right of the former trustees that were common ground between the parties were an entitlement to apply for judicial sale or to appoint a receiver over trust assets in aid of its right of indemnity. His Honour considered that entitlement was sufficient to entitle the former trustee to obtain interlocutory relief to prevent the transfer of trust assets. In considering the case law on the effect of a receivership order, Justice Leeming opined that many authorities spoke of the limited entitlement conferred by the former trustee's rights over the trust assets, often described as a charge or a lien. Justice Leeming considered that the sui generis nature of the former trustee's proprietary rights was important to bear in mind and cautioned against deploying general principles relating to charges or liens. His Honour therefore proceeded on the basis of first principles when considering the nature of the former trustee's interest in the trust property. His Honour made the point that merely having custody and administration of property on behalf of others does not convert a person into a trustee. His Honour gave the example of a trustee holding Torrens system land on trust which is mortgaged. Although the mortgagee has a proprietary interest in land, which takes priority over the beneficial interest of the beneficiaries, it cannot prevent an in specie distribution to beneficiaries. The trustee thus does not owe fiduciary obligations to the mortgagee, and no constructive trust will be imposed. His Honour cited well-known cases, Hospital Products and United States Surgical Corporation, John Alexander's Clubs and White City Tennis Club, and noted that the critical feature of a fiduciary relationship is that the fiduciary undertakes to exercise a power for or on behalf of another person in the interests of that person. His Honour considered it difficult to see how the successor trustee could be said to be exercising the trustee's power for or on behalf of the former trustee. It was noted that the successor trustee had duties to the beneficiaries and could be compelled to exercise its powers for their benefit, such as in the case of a Saunders and Vautier direction. His Honour emphasised the difficulty of reconciling fiduciary obligations owed to a former trustee with the fiduciary obligations owed to beneficiaries. On the point of vulnerability, which all three of their honours considered was relevant to take into account, Justice Leeming noted that the former trustee was no less vulnerable than any other creditor with a security interest recognised in equity. His Honour pointed out that, again, the rights available to the former trustee, that it could protect its security by way of caveat or injunction and could enforce it through judicial sale. A final point of discomfort for His Honour was the issue of when the fiduciary obligation would arise, as the successor trustee may not be aware of the existence or extent of the former trustee's claim for indemnity. In oral submissions before the Court of Appeal, counsel for Mr Neyman argued that the fiduciary duty arose upon the successor trustee learning of the existence and size of a realistic claim for indemnity from the former trustee. Justice Leeming described this position as, quote, decidedly odd, unquote, and distinct from any recognised category of fiduciary duty. Ultimately, His Honour emphasised the strength of the remedies available to the predecessor trustee, even without the imposition of a fiduciary obligation, and concluded that it was unnecessary to superimpose a fiduciary duty between the current and former trustees, and wrong to reason that because equity would grant relief on the application of a former trustee, then the former trustees were owed a fiduciary obligation by their successor. Summarising his findings, they were as follows. As a starting point, JPG was entitled to be indemnified for liabilities properly incurred in the office of trustee. While in office, JPG had legal title to trust assets which it could use to indemnify itself. Following its removal from office, JPG continued to have recourse to trust assets to discharge those liabilities. Although not through ownership in law, it could apply to the court for the appointment of a receiver. At that point, Jakin held the trust assets on trust subject to JPG's prior ranking entitlement to have recourse to them, which could be vindicated by the appointment of a receiver. But none of those matters gave rise, in His Honour's opinion, to a fiduciary obligation owed by Jakin as successor trustee to JPG as former trustee. Now, this finding had obvious consequences for the claims of liability for knowing receipt or assistance pursuant to the principles in Barnes and Addy. On the facts of the case, Mr Neyman, as a creditor of the trust, was nonetheless entitled to have recourse to trust assets, including pursuant to statutory prohibitions on the voluntary alienation of land with the intent to defraud creditors. I think there's no doubt that the transfer of the trust assets was with intent to defraud the creditors. Justice Kirk agreed with Justice Leeming, as I've indicated. He made some brief remarks on the character of the obligation owed to the successor trustee. He emphasised that there are many circumstances in which a party is vulnerable to the actions of another, but where there is no fiduciary duty nor any duty of care, and he gave examples in relation to that. His Honour thought vulnerability was a relevant factor, but in general, alone it would not be sufficient to cause a fiduciary duty to arise. So echoing Justice Leeming, Justice Kirk questioned how the relationship of former trustee and successor trustee could be distinguished from other circumstances in which one holds property in which another has some interest, such as a mortgagee, a person with some security interest, charge or equitable lien. His Honour thought that to apply a fiduciary relationship would significantly expand the role of fiduciary duties. So, having heard that, you might wonder what room there was for dissent. But there was dissent. The Chief Justice, in dissent, agreed with the primary judge's conclusion that a fiduciary obligation was owed by Jakin to JPG and had been breached, with the consequences that third-party knowing assistance should be able to be pursued for equitable compensation under the principles in Barnes and Addy. His Honour set out the chief concern of fiduciary law as described by the late Justice Finn, then Professor Finn, in his article, The Fiduciary Principle, and in his fiduciary obligations, and that this was to impose standards of acceptable conduct on one party to a relationship for the benefit of another, where the one has a responsibility for the preservation of the other's interests. Its function, therefore, is to secure the paramountcy of one side's interests. The Chief Justice acknowledged that vulnerability was not the touchstone of fiduciary obligation, so he was in accord with the majority on that point, but he emphasised it was a relevant factor. And he noted the importance of vulnerability in particular relationships, such as the fiduciary obligation owed by a mortgagee holding surplus proceeds of sale. He also gave us another example, the fiduciary obligations owed by a bailee to a bailor. His Honour thought it would scarcely be a radical step to recognise that a successor trustee was under a similar obligation when in custody of trust assets which were charged in equity with its predecessor's right to recoupment. His Honour emphasised several aspects of the relationship, including that the predecessor trustee's beneficial interest takes priority over the interests of ordinary creditors. His Honour thought it anomalous that a successor trustee's duty to those with an inferior interest in the trust property, i.e. the beneficiaries, would be fiduciary, while its prior ranking duty to the predecessor trustee would not. His Honour also called attention to the fact that the former trustee was entirely out of possession of the trust assets. Also, in contrast to the majority, His Honour had no concern with the issue of when the fiduciary obligation would arise. He accepted the submission that it would arise no later than when the successor trustee became aware of the former trustee's claim to indemnity. He also had no difficulty in reconciling the fact that the successor trustee would owe fiduciary duties to both the beneficiaries and the former trustee, noting the long-standing rule that a trustee is not required to make a distribution to the beneficiary to the extent that the beneficiary still has outstanding obligations to the trust. So the Chief Justice, in concluding, in describing what he said was the important difference in his analysis from that of the majority, noted that while their Honours had emphasised that the former trustee's interest was in the nature of a charge over the trust assets, he placed greater weight on the characterisation of the interest as a beneficial interest in the trust estate, given that starting position and noting the superiority of the interest over the interests of beneficiaries to whom fiduciary duties were owed. His Honour viewed it as surprising that the superior interest should not be protected by a fiduciary obligation. So quite stark differences in the reasoning between the majority judges and the Chief Justice in dissent. There is an interesting article on this by a lecturer at the University of Sydney, Mr. Ariane Mohseni, which goes through the decisions, but I think in the interests of time, I'll simply note that the point of difference implicit in his argument is that the former trustee's so-called beneficial interest is limited to its right of indemnity and is distinct from the full beneficial interest employed by the beneficiaries of the trust. He noted that the former trustee can trace into disbursed assets irrespective of whether a fiduciary relationship existed between it and the successor trustee. And he questioned whether it was even necessary to ask for the purposes of establishing Barnes and Addy liability against third-party recipients, whether any duty owed to the former trustee was fiduciary in nature. His encouragement is to focus on the limited content and function of a party's equity rather than seeking to characterise it and label it, and then he would argue syllogistically reason therefrom, and that this was consistent with the caution expressed by the majority judges against a hasty widening of the categories of fiduciary relationship. So, as I say, there's been some academic support that I've read from in England in relation to for the dissenting view as to the protection of the superior interest of the former trustee over the interests of beneficiaries. And it seems to me that it's an interesting reminder to view equitable interests through the rights that they confer rather than the taxonomical category within which they fall. And as noted earlier, we await with interest the decision of the High Court on the issue, although when I asked one of the High Court justices last week if there was any chance it would be handed down before today, I wasn't given any encouragement that it would. As an additional note on Jakin, in the United Kingdom, there is a case, Equity Trust Jersey Limited and Halabi, which offers further judicial consideration of the nature of a former trustee's rights in relation to trust assets. That case involved a priority dispute between former and successor trustee of a discretionary trust with liabilities that substantially exceeded its assets. The former trustee, Equity Trust, had argued that its right of recourse to the fund should take priority over other creditors, including Halabi, on a first-in-time basis. Equity Trust was unsuccessful before the Royal Court of Jersey, but was successful on an appeal to the Court of Appeal of Jersey before the matter ultimately came before the Privy Council. Halabi was heard concurrently with a case from Guernsey in which the Guernsey Court of Appeal had held that the claims of a former trustee had priority over those of successor trustees, and that trustee claims had priority over creditors claiming through them as subrogated to their lien. As a preliminary issue, the Privy Council held that a trustee's right of indemnity conferred a proprietary interest in the form of an equitable lien, and that the proprietary interest survived the transfer to the successor trustee. However, the Privy Council overturned both courts of appeal to which I've referred, with the majority concluding that the former and successor trustees' interests in the trust assets rank pari passu, where those assets are insufficient to meet the claims made by or through the trustees pursuant to their indemnities. Lord Briggs, with whom Lord Reid and Lady Rose agreed, considered the nature and purpose of the trustees' lien, concluding that successive trustees' liens were not intended to be in competition with each other. Where the trust assets were inadequate to satisfy the indemnities, they considered the trustees had suffered a, quote, shared misfortune, unquote, in a single continuing institution and as such should recover pari passu. It was significant to Lord Briggs that the trustees' lien was the vehicle for trust creditors to be repaid by subrogation to the lien. To expect creditors to be aware of the various dates of appointment and to determine priority on that basis was, to his lordship, contrary to justice, fairness, equity and common sense. Lady Arden, agreeing but writing separately, concluded that to adopt a first-in-time rule would be inconsistent with equitable principle. Her ladyship also noted the disadvantage successor trustees would be under, given the difficulty they might have in determining or verifying the various liabilities of former trustees. This lack of visibility, with earlier liabilities given priority, might, in Lady Arden's view, have a very damaging effect on the willingness of persons to do business with a trust. Lord Richards and Sir Nicholas Patten, with whom Lord Stevens agreed, dissented, emphasising that the right of indemnity existed to protect the personal position of each trustee by giving them a right to seek an order for judicial sale, and contrasted this to a lien representing security for the payment of a debt. As such, he considered that the interest of successive trustees, they were competing and fell under the general principle granting first-in-time priority. A common thread throughout the judgments, including the dissenting judgment, was a focus on the characterisation of the right of indemnity as an equitable lien over the trust assets. Though the question of any fiduciary obligations as between the former and successor trustees was not an issue before the Privy Council, the conclusions they reached align with the majority position of Justices Leeming and Kirk in the Jakin decision. Indeed, Halabi was specifically cited in Justice Leeming's judgment, in which His Honour noted that the decision was inconsistent with a fiduciary duty being owed in relation to the former trustee's entitlement to have recourse against the trust assets, because if a fiduciary duty were owed in relation to those assets, then the pro rata ranking of the interests of former and successor trustees, which the Privy Council upheld, would have been replaced by priority being given to the former trustee's entitlement. Arguments along the lines of those advanced in Jakin were not addressed to the Privy Council in Halabi, and Justice Leeming noted that, but considered that this reflected the novelty of the argument which was before the New South Wales Court of Appeal. And what His Honour suggested was the associated low likelihood that a fiduciary relationship would be recognised. Famous last words until we hear what the High Court says on that one. Now, from a practical point of view, you may well say that what these cases illustrate is the importance of outgoing trustees to secure indemnification before control of the trust passes to the incoming trustee, or to adopt an analogy that might have had some force in the recent High Court decision on torts, which I won't be talking about tonight, namely Mallonland and Advanta Seeds, to shut the door before the horse or mule has bolted. You might know that that's the case where Justice Edelman started his dissertation in relation to the issue by saying we do not breed from a mule, quoting an earlier decision. The second of the areas that I wanted to talk about tonight was the doctrine of fraud on a power. That has also been the subject of academic and judicial consideration of late. Now, as you will know, the origins of the doctrine go back to the English cases of Topham and Duke of Portland and Vatcher and Paul. Fraud on a power is defined in Vatcher and Paul as an equitable doctrine prohibiting the exercise of a power in certain circumstances for a purpose or with an intention beyond the scope of or not justified by the instrument creating the power. A power, such as a trustee power, must only be exercised with good faith and sincerity, having regard only to the purpose and object of the power. The use of the word fraud can be misleading in this context. Fraud on a power does not indicate any dishonesty, simply action beyond the implied scope of the conferred power. The doctrine's express adoption in Australia was seen in the High Court decision of Nurley and McCann in 1953, which cited both of those cases. In more recent case law, the sentiment as to the meaning of fraud in this context has been considered. In the Court of Appeal of Western Australia, it was elaborated on in McCanty and McCanty, and in New South Wales, the judgment of Justice Brereton in Barber and Sheehan. In Barber and Sheehan, Justice Brereton described the doctrine as requiring that a power be exercised bona fide for the purpose for which it was conferred, but went on relevantly to say that such an exercise of power for an extraneous purpose is invalid and void. And that's the issue that has been given some focus as to what is the consequence of exercising a power that in a way that comes within the context of fraud on a power. Justice Brereton concluded that the concern of the doctrine was on the purpose for which the power was conferred on its repository. While the language of fraud on a power was used throughout the various judgments that he referred to, the emphasis by the judges was that the relevant conduct is distinct from dishonesty or immorality, and the focus was on the purpose of the power. Now, this sets the stage for recent developments in the area which have advocated for a change in terminology. Another name for the doctrine is the proper purpose rule, which controls the exercise by trustees of their powers, whether conferred on them by general law or by the trust instrument, by requiring the power be exercised for the purpose for which it was conferred. The propriety of those descriptors as labels for the doctrine was the subject of a recent decision of the Privy Council in Grand View Private Trust Company and Wen Young Wong in 2022. Now, that case related to two trusts in Bermuda set up by two brothers. The first was a fully discretionary trust set up for the benefit of the brothers' family. The second was a purpose trust for the perpetuation of the brothers' business, along with some charitable purposes. Relevantly, the second trust conferred no benefit on family members. In 2005, the trustees of the discretionary trust excluded the family members from the beneficial class of the trust and added the trustee of the purpose trust as the sole beneficiary of the discretionary trust. All assets of the discretionary trust were then appointed to the trustee of the purpose trust. The trustees justified their action on their powers in the trust deed, which permitted them to add or remove any person or class or description of persons to the beneficiaries of the trust. Unsurprisingly, various heirs of the brothers brought proceedings against the trustees seeking to restrain the action. At first instance, the Supreme Court of Bermuda found for the heirs, concluding that in removing the family beneficiaries, the trustees had altered the substratum of the discretionary trust, as its underlying character was an irrevocable settlement for the benefit of family members. The trustees were successful in their appeal to the Bermuda Court of Appeal, which held that there was no standalone rule that an exercise of trust powers could be set aside on the basis that it affected the substratum of the trust. The Court of Appeal also held that the exercise of powers had been for a proper purpose and it could be used without regard to the interests of existing beneficiaries. The Privy Council allowed the family members' appeal, holding that the amendments to the beneficial class of the trust were void. While agreeing with the Court of Appeal that the substratum rule did not exist as a freestanding absolute rule which would in all circumstances subscribe powers of amendment, Lord Richards, with whom Lords Hodge, Sale and Burrows and Lady Rose agreed, emphasised that the underlying purpose of the trust was of central importance in determining whether the actions were within power. Now, as to the effect of the finding, Lord Richards noted the debate that I adverted to earlier as to whether the purported exercise of power would be void or voidable. In that case, the parties had agreed that the decision would be void. This aligns with the apparent Australian position on the issue, with Justice Brereton in Barber and Sheehan stating that an exercise for an improper purpose would be invalid and void, but that is not beyond doubt. As could be foreseen in even the earliest decisions on this topic, the Privy Council were critical of the use of the term fraud on a power, due to the potential application of the proper purpose rule, even to good faith and to genuine actions by a trustee. Lord Richards noted the description of fraud on a power by the New Zealand Supreme Court in Kane and Hutton as, quote, historical language, unquote, and the remarks of Lord Sumption in Eclairs Group and JKX Oil and Gas that it was an inappropriate term. His Lordship went so far as to advise that the Privy Council considered that there was much to be said for discarding this historical language and referring instead to the proper purpose rule. A Canadian lawyer and author has written an article in this one headed Goodbye and Good Riddance to the doctrines of fraud on a power and the entire substratum. Now, if only we could figure out the proper purpose rule. So to conclude my discussion tonight on the question of fraud on a power and the proper purpose rule, I want to briefly return to the question of the effect of the doctrine, and I do so by reference to an article that was written by Dr. Jessica Hudson, who currently is a barrister but who fortuitously was previously my tipstaff. And one of the arguments set out in her article, One Thicket in Fraud on a Power, is the effect of fraud on a power and whether it can be described as void or voidable. Dr. Hudson considers that it can be described as neither, and that the more important question is as to the priority of equity's response to the improper exercise, which will be determined by the interaction between the doctrine and the type of power purportedly exercised. The scope of the article encompasses a broad sweep of private powers, considering institutions such as companies and agencies in addition to express trusts. For the purpose of this paper, I am confining myself to the commentary on express trusts. As a preliminary point, Dr. Hudson emphasises that the doctrine should be viewed, at least in principle, as imposing a disability rather than a duty on the holder of the power, such that the object of the power enjoys a correlative immunity from exercise, i.e., the object's legal relations cannot be changed by the purported exercise of the power for an improper purpose. Subsequently, Dr. Hudson notes the importance of the context of the power, stating that in some settings, the doctrine imposes an actual disability and actually confines the scope of the power, while in other contexts it does not confine the scope of the power but generates an equity for relief, as if the donee were disabled, something that she describes as an in-principle disability. Dr. Hudson, therefore, advocates against an approach aiming to characterise the effect of fraud on a power as either void or voidable, arguing that the better approach is to look to whether an actual or in-principle disability is imposed, which allows for consideration of the type and priority of the equity for relief that is generated. A key aspect of the argument is the importance of distinguishing between various powers. Dr. Hudson states that powers that vary, create or extinguish equitable interests are only effective to the extent that the court would order the person holding title to the relevant property to act in accordance with the exercise of the power. In the case of a fraudulent exercise of power, the court would not make such an order. So in this sense, Dr. Hudson argues that the purported exercise of power, if for an improper purpose, is ineffective. that the court would not grant the relief that would be required. In cases of exercise of a power for an improper purpose being ineffective, she suggests that this is demonstrated also by the fact that ratification by the beneficiary is not possible. Rather than being effective but capable of being set aside, the purported exercise of power is ineffective from the outset. In contrast, where the power is a power of a trustee to deal with the legal title to trust property, fraud on a power does not prima facie limit the scope of the power. As the power to deal with property is an incident of the trustee's title, the scope of the power is determined by the applicable law. But where fraud on a power may give effect to an in-principle disability is where the doctrine has disabled the exercise of the separate power to overreach the beneficiary's interest. In her article, she refers to cases such as Wong and Burt, where a trustee transfers title to trust property to third parties for an improper purpose. Although the transfer itself is not rendered ineffective and the third party does receive title, the beneficiaries are able to rely on their pre-existing equitable interest to seek recovery of the property. And Dr. Hudson uses this example to demonstrate that the labels of void and voidable are not helpful. The trustees dealing with the title is voidable in the sense that the transfer is effective in conferring title, but it can also be described as void due to the doctrine disabling the trustee's power to overreach. In recent significant cases, to consider fraud on a power, the discussion of the effect of the doctrine has either been a non-issue, such as in the Grandview case, or when considered in any depth, for example in Pitt and Holt, has largely been confined to a discussion of whether the purported exercise of power is void or voidable. The last case, if I've got time to give some discussion to, is one which I am closely watching the High Court's view on since I wrote the lead judgment, and that is Kramer and Stone. And this was one of your, you might have thought, one of your standard proprietary estoppel cases, but it did raise an issue which I suspect may have been the reason that special leave was granted, as to the requisite standard of knowledge on the part of the representor for an estoppel by encouragement to be made out. I say that because, with some hesitation, because having read the transcript of the argument before the High Court, it doesn't appear that it was argued in that way, but we're all used to having arguments run in higher courts that bear no resemblance that was run, the ones that were run below. In any event, the case involved a dispute around a farming property in the Hawkesbury region of New South Wales. And for those literary buffs amongst you, it was owned by the late Dame Leonie Kramer, who was a professor of literature at Sydney University for a number of years. And I did attend one of her lectures when she was there in that position. And it was following the death of her late husband, Dr. Kramer, Dame Leonie's final will left the property to her daughter, Hilary, the first appellant. Mr. Stone, the respondent, brought proceedings alleging that he was entitled to the property on the basis of an equitable estoppel. He had farmed the property under an oral share farming agreement since 1975, and he claimed that Dame Leonie had made a representation to him that he would receive the property on her death, following earlier representations to the same effect made by Dr. Kramer. The primary judge, Justice Robb, found for Mr. Stone. He considered him to be a quote, very exceptional witness, and Justice Robb held that the property was held on constructive trust for him on the basis of an equitable estoppel arising out of the representation by the deceased. He agreed that Mr. Stone had relied on the representation to his detriment, and he found, and this is where the argument as to knowledge came in, that Dame Leonie, quote, ought reasonably to have assumed, unquote, and, quote, ought to have known, unquote, that Mr. Stone had continued with the share farming agreement on the expectation that he would inherit the property. The primary judge specifically addressed the standard of knowledge required of the representor, stating that subjective knowledge on the part of the representor is not essential, provided that a reasonable person in the position of the representor would understand that it was probable that the representee was engaging in the conduct in the expectation that the representation would be realised. This was in reliance on statements made by Justice Dean in Commonwealth of Australia and Beirne that, quote, a critical consideration will commonly be that the allegedly estopped party knew or intended or clearly ought to have known that the other party would be induced by his conduct to adopt and act on the basis of the assumption, unquote. On appeal, which was before a court constituted by Justices Leeming, Kirk and myself, the appeal being brought by Hillary and her co-executor, a key issue was whether it was necessary for there to have been a finding of actual knowledge by Dame Leone that Mr Stone had acted to his detriment where constructive knowledge had been made out. The appellants contended that for a case of estoppel by encouragement, actual knowledge was required, citing the judgment of Justice Brennan in Walton Stores and its explicit acceptance in the New South Wales Court of Appeal in the cases of DHJPM and Blackthorn Resources and Dwayhe and Construction Technologies Australia. The appellants argued that the requirement in a Dillwyn and Llewellyn proprietary estoppel case that the representor knew or intended that the representee would act to their detriment had its genesis in Lord Kingsdown's dissent in Ramsden and Dyson, quoted by both Justice Brennan in Walton Stores and Justice Marr in DHJPM. The appellants emphasised that Justice Brennan's matters necessary to establish an equitable estoppel included the requirements that the plaintiff acts or abstains from acting in reliance on the assumption or expectation, and that the defendant knew or intended him to do so. So knew or intended him to do so. As to the clearly ought to have known formulation applied by the primary judge in reliance on Justice Dean's judgment in Beirne, the appellants noted that His Honour's statement of either of the general doctrine of estoppel by conduct had not been accepted by this court or the High Court. The appellants characterised the case as an orthodox proprietary estoppel case involving an estoppel by encouragement and argued that the primary judge was bound to apply the test of actual knowledge and erred in applying the constructive knowledge test. So, I considered that in a case of estoppel by encouragement, the question of the representor's knowledge of reliance went to whether departure from the representation would be unconscionable, so as to warrant equitable intervention to prevent the defendant resiling from the representation. It seemed to me that knowledge of acts in reliance on the representation was a necessary element for a proprietary estoppel by acquiescence, since in that case it is the knowledge and standing by that engages the conscience of the party sought to be estopped, but not necessary in an estoppel by encouragement case where the conscience has been sufficiently engaged through the encouragement made by the representation in the first place. I considered that this approach resolved what was a seeming conflict between the approaches by Justice Dean in Beirne and Justice Brennan in Walton Stores, and enabled cohesion with the standard of proof borne by a plaintiff in proving the detrimental reliance, which was also an objective standard. As the focus of equitable estoppel is on unconscionability, knowledge of the acts undertaken in detrimental reliance on the representation or promise is relevant, but not, I thought, essential in a case of estoppel by encouragement. The encouragement in making the representation should be sufficient to satisfy the requirement of unconscionable conduct where there has in fact been reasonable reliance on the representation. I should add here that Mr Stone, the share farmer, from reading the transcript and the primary judge's judgment, was laconic in the extreme, and the likelihood that he would have had conversations with Dame Leone as to what was going to happen after the original conversations was perhaps pretty limited. In any event, on the facts of the case, it was my view that the finding that the deceased ought to have known of the detrimental reliance did not demonstrate error in the finding of estoppel by encouragement. And so it was not necessary for me to express any concluded view as to whether any such knowledge must be actual or constructive. Justice Leeming agreed but wrote separately on the issue and did express a view as to the standard of knowledge required. His Honour considered that while the point was not yet settled, the weight of authority nevertheless suggested that actual knowledge was not necessary. And I won't go further through His Honour's judgment, but you can, of course, read it if you wish, and he agreed with me in the end. What was made clear in both, I think, is that the focus in any species of equitable estoppel must be on unconscionability, specifically whether the departure by the defendant from an assumption adopted by the plaintiff was or would be unconscionable. It seems to me logical, therefore, that any knowledge requirements on the part of the defendant depend on how the assumption was formed. In the case of express and intentional encouragement, then it will likely be unconscionable for the representor to resile from the assumptions they've created, regardless of the actual knowledge of steps taken pursuant to that assumption. In contrast, where the estoppel involves a defendant standing by in silence as the plaintiff labours under an incorrect assumption, it is necessary that the defendant had knowledge of that assumption. That position has been explicitly advocated for, if not so clearly by the courts, by academics for some time, and Justice Lemming has quoted some academic articles to that effect. In the High Court, the argument, at least by reference to the transcript, appears to have been put somewhat differently, as I indicated earlier. It was said there that there were two cascading propositions. First, that in the field of proprietary estoppel by encouragement, the equity arises in favour of an intended donee from the conduct of the donor after the element of encouragement that is said to give rise to the relevant unconscionability. And second, that in a case where the only conduct of the donor after making the voluntary promise is said to be knowledge of the detrimental reliance, then constructive knowledge is insufficient for that purpose. In any event, it may be that the High Court takes a different view from the New South Wales Court of Appeal on that one as well, in which case we'll be very interested in reading the outcome, but my inquiries last week also suggested that one's not yet ready to be handed down. So, I've spoken before and written in conclusion, I would say, about the etymological derivation of equity, the Roman equitas. And I've observed that on some accounts, the contemporary principles of equity can be traced back even further than ancient Rome. The articulation by Aristotle of the justification for equity as a correction or rectification of law where it is deficient on account of its universality accords with Professor Lee's emphasis to me in our telephone conversation when preparing this paper on conscience as the foundation of equity or equitable principle, the bright thread of equity, namely the correction of common law. The continuing development of equity, even after hundreds of years, is, I think, nothing short of remarkable. The doctrine of fraud on a power, 300 years after it was created, by what one academic has referred to as one judge's off-the-cuff remark, now sees a significant overhaul, at least in respect of terminology, and likely through a simplification of the approach taken to an allegation of fraud on a power, or as now we are encouraged to say, improper purpose. Even since Grandview, however, the historical language of fraud on a power has continued to be used in Australia. See, for example, in Soulos and Pagonas, albeit in passing. So it will be interesting to see if both the terminology and approach advocated for by the Privy Council are adopted in this jurisdiction if a case arises in which it is a central issue. I'll simply be interested to see whether a case arises in which there can be consideration to Dr. Hudson's arguments regarding the effects of the doctrine. All of which goes to say that the future for academics and lawyers generally on debate as to equitable principles seems to me to be bright. And as to the apocryphal length of the Chancellor's foot, which I have to say in my day was generally shod with quite fashionable shoes, if I do say so myself, will remain relevant for quite some time to adopt John Scythen's well-worn aphorism for equity's measure. Thank you for your attention. I probably talked too long.
Thank you very much, Justice Ward. I know this excellent presentation required a great deal of thought and effort. It also took a lot of time, a sparse commodity for the President of the New South Wales Court of Appeal, Australia's busiest intermediate appellate court. Justice Ward, we're honoured you made the time in your extremely busy life to travel to Brisbane to give this excellent presentation. And thank you for your time, your intellectual rigour, and for generously sharing your insights about recent trust and equity cases with us this evening. Perhaps we'll need to get you back next year to find out what the High Court did in those two cases. Thanks also to Chief Justice Boscawen for her continued support of this lecture series and for permitting it to be held in this magnificent space, and to Justice Bond for so graciously welcoming and hosting us this evening. There would be no WA Lee Equity Lecture without Professor Tony Lee, now in his 95th year and sadly unable to be with us this evening. As Justice Ward has indicated, he still follows this event and the law of trusts and equity with great interest, and I know he was thrilled that Justice Ward was able to deliver this 25th lecture. I thank Professor Lee for all he has done in the Legal Academy in Queensland and far beyond. My next thank you is to tonight's major sponsor, the TC Beirne School of Law, University of Queensland, represented this evening by Professor Rick Bigwood, and our networking drinks sponsors, De Groot's Wills and Estate Lawyers, Estate First Lawyers and Mitchell's Solicitors. Thank you, Professor Bigwood, on behalf of the University of Queensland for sponsoring this important lecture series. Always an intellectual legal triumph, as it certainly was tonight. And for introducing Justice Ward so ably. Queensland Community Foundation, Queensland Gives, under the stewardship of the Queensland Public Trustee, is the state's largest public charitable trust. I have the honour to chair its Advisory Board of Governors and am delighted that it organises this annual lecture. Queensland Gives started in 1997 with start-up funds of $300,000 under the leadership of then Premier, the Honourable Micah Hearn AO, our former patron, who sadly passed away last year. I warmly acknowledge Mike's daughter, Claire Welch, who's with us tonight and is a great supporter. Queensland Gives Capital Fund has grown in those 27 years to around $139 million, largely thanks to donations in wills from those who wish to provide an everlasting intergenerational gift to Queenslanders in need. Queensland Gives is also supported by living philanthropists who wish to encourage giving in their families or businesses. We now have over 250 sub-funds supporting over 300 Queensland charities each year and onwards forever. Every tax-deductible dollar donated to a Queensland Gives sub-fund is wisely invested by our founding partner, QIC, with income distributed annually to Queensland charities. We have sub-funds for specific charities or types of charities, or sub-funds where living donors decide which charity to support each year. We have a general fund to give support wherever it is most needed. And we have regional funds promoting a give where you live philosophy. In the coming year, Queensland Gives will provide over $5.7 million, a new record to help charities all over the state, from Currumbin to Cunnamulla to the Cape and everywhere in between. It's fitting that Queensland Gives then organises this annual equity lecture. The concept of equity in its broadest sense, as Justice Ward has said, going back to Roman times and perhaps beyond, encompasses a notice of fairness, of social inclusion. Queensland Gives is committed to a socially inclusive Queensland, distributing wealth from generation to generation on a needs basis, today, tomorrow and forever. Queensland Gives also celebrates and encourages Queensland philanthropy generally, not just those who donate to us, with our prestigious annual Philanthropy Awards and our Philanthropy in Focus photographic challenge. Uniquely, Queensland Gives generous sponsorship from founding sponsors QIC and Anglo Coal and our other sponsors means that every tax-deductible dollar donated to QCF goes straight to its capital fund, providing that perpetual income stream for charitable purposes. All this makes Queensland Gives, and there's nothing as a free drink. I know you're all looking forward to it, but you've got to wait to hear this before you can get your free drink. All this makes Queensland Gives the ideal vehicle for you or your clients to become philanthropists with the gift that keeps on giving through either a tax-deductible donation of as little as $2 or by establishing your own named charitable sub-fund, whether by legacy or as a living donor, and without expensive set-up costs or ongoing worries. One of our sub-funds of particular interest to this audience will be Law Rights Civil Justice Fund. So if you're interested, please contact our helpful Queensland Gives team or go to our website to learn how you or your clients can be part of the Queensland Gives enduring legacy. And finally, thank you all for making time in your busy lives to join us for this special evening, which we will now continue outside the courtroom with drinks, savouries and conversation stimulated by Justice Ward's excellent presentation. Thank you.